This is Bart Peterson, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
This is Greg Gilchrist, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
This is Dan DeMarco, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
In this episode of the FCPA Compliance Report, I'm joined again by Morrison & Foerster partner James Koukios to talk about the firm's December 2020 International Anti-Corruption newsletter. We take up the first CFTC FCPA enforcement action. We consider the Patrick Ho conviction and its upheld on appeal. The Brazilian government announces a 5-year ABC enforcement plan. MPP settles car wash enforcement action, and we discuss the ABC reforms introduced in the National Defense Authorization Act. It's a fascinating episode. I know you will enjoy it. The FCPA Compliance Report is a production of the Compliance Podcast Network and a proud member of C-Suite Radio. Thanks so much for listening. Hello, everyone. This is Tom Fox, back for another episode, and I'm back with James Koukios, partner at Morrison & Foerster, to discuss the firm's always great monthly International Anti-Corruption newsletter. Today, we're going to take up the December newsletter. So, James, with an incredibly long-winded introduction, first of all, welcome, and thank you so much for taking the time to visit with me today.
Thanks for having me today, Tom.
James, in late, I guess not late December, but in December, we had one of the most fascinating FCPA enforcement actions to me, and that was the Vital case. Lots of different interesting facts, but the one I wanted to visit with you about and have wanted to visit with you about is the CFTC component of this. This Vital was energy traders, and part of the bribery allegations were in the trading end of things. They were engaging in deceptive trade, which jacked up the price in the market, but also that they were bribing foreign government officials, or rather employees of instrumentalities of national oil companies. And that's been going on in Houston, frankly, a long time. And I've tried to tell people years ago, hey, these traders are potentially, they have FCPA exposure, and you need to look at that. But this was the first enforcement action. So I guess I wanted to get your comments on that. And then what about the CFTC and their involvement in this?
Well, Tom, as always, you were very prescient, and you forecasted that, and you got that right. So good job on that one. Proved right with this enforcement action. Yeah, it's very interesting that the CFTC has got involved in the foreign bribery enforcement. They announced that they were going to do that back in March of 2019. They announced that from now on they're going to be a player in the foreign bribery enforcement arena. One thing to clear up, because I hear some people say this sometimes, is the CFTC does not enforce the FCPA. So unlike the SEC, which does enforce the FCPA against issuers, the CFTC is not enforcing the FCPA itself. What the CFTC is doing is they're enforcing their statute, the Commodity Exchange Act, in terms of how it might be impacted by foreign bribery. So that just as a technical matter, they're not FCPA enforcers, but they are now foreign bribery enforcers using their own statute.
Thank you for so gently correcting me.
Yeah, no, you didn't do it. It's actually people that I've tried to explain to you before in the past. And it's kind of a technical distinction also. But so, what that means is that the CFTC only gets involved when there's a commodity. So they're not going to be able to be involved in just, FCPA generally. They have to have a theory where an act of foreign bribery has impacted a commodity. And in this case, they said that the foreign bribery that was paid by these traders harmed market participants, undermined the integrity of the U.S. and global physical and derivatives oil markets, and defrauded counterparties as well. So it's very interesting. They found a way where they said that this affected the commodities markets and so fell in their jurisdiction. I will say it's been very interesting. When I was at DOJ, we obviously worked very closely with the SEC. And if we ever got a call, for example, from an issuer to self-disclose an FCPA violation, I would always ask, have you also called the SEC? Because we were going to pick up the phone and call the SEC if they didn't. And most of the time, the answer was, we're about to, or yes, we have. So, there was no situation where I actually had to call the SEC myself. The CFTC now is sort of in that posture as well. They work very closely with the fraud section, both in the market integrity and major frauds unit, where they've done a lot of commodities fraud cases not involving foreign bribery. And now they're working very closely with the FCPA unit at DOJ as well. And so, unfortunately, now for companies who may have commodities involved in their foreign bribery issues, there's another player involved, and they have to think, when I call DOJ or when I call SEC, if it's an issuer, do I also need to call the CFTC? And I've had an experience where that's exactly what happened. There was a self-disclosure to DOJ, and a day later I got a call from CFTC saying, we heard from DOJ that you did a self-disclosure. We'd like to hear about this also. So, CFTC is here. They're now involved in the foreign bribery arena, and it's important for companies who have in the commodities markets who have a potential foreign bribery issue to consider the CFTC as well. Now, the good news, if there is good news, is that the CFTC, like DOJ, essentially announced an anti-Pilot 9 policy and said that they were going to work together with other enforcement authorities to make sure that there wasn't unfair double penalizing. And what we did see in the Vital case was actually, even though on paper it was a $95 million total penalty to be paid to the CFTC, the CFTC actually credited the DOJ resolution. And so the additional penalty ended up being much smaller than that $95 million number. So it's important if you do find yourself in that position to try to coordinate those resolutions between CFTC and the other enforcement authorities. So if there is any credit that you can get, you make sure that you get that.
James, one of the themes I saw in 2020 and overall anti-corruption enforcement was not simply greater cooperation between the Department of Justice and other federal government agencies, but actually additional enforcement actions, or at least contemporaneous enforcement actions. We saw the OCC, we saw the New York State Department of Financial Services, we saw the CFTC, we've seen OFAC. Is that a trend that you would see continuing by the Department of Justice and now under the Biden administration?
For sure. I mean, DOJ, I think, has shown itself to be willing to work with other law enforcement authorities or other regulators quite a bit. Sometimes the onus, though, is on the company to raise those issues and to ask DOJ for their assistance in doing that. So, for example, I was just on a panel with Chris Sestero from the head of the FCPA unit at DOJ, and I was asking him about that, and he said, it's really up to the company. If you want to have a coordinated resolution, you should let us know that up front. Don't let us know this at the very end. If we've gone 3 years with you and we're about to resolve with you, and then you say, oh, wait, can you also bring in such and such an agency to coordinate this resolution? So as long as the company is thinking about that ahead of time and raises it to DOJ, and DOJ has good relationships with those enforcement authorities, that is something DOJ will definitely be interested in doing. It doesn't have those relationships with all enforcement authorities, both domestic and foreign, but to the extent that there is something that DOJ can do about it, they are willing to do that.
James, we had a individual conviction upheld in I believe the Second Circuit, and that was Patrick Ho. And I don't want to say it went under the radar, but it seemed to me to get a lot less play than, for instance, the Hoskins case. But it was equally fascinating from our law geek perspective. It certainly, I thought, had some interesting issues around jurisdiction. And I was wondering if you could maybe explain this case a little bit for us.
I have to agree with you, Tom. I spent a lot of digital ink on this one. That entry is pretty long because it was really packed full of very technical and first impression FCPA issues. So I thought it was pretty interesting. It probably didn't help, Tom, that the Second Circuit released it on December 29th. After Christmas, before New Year's, during the pandemic, with the world waiting to see what would happen on January 6th. Probably didn't help very much, but it really is worth reading if you practice in this space. So long story short, in March of 2019, Patrick Ho, who was an officer and director of a U.S.-based NGO, which was funded by a Chinese energy company, was found guilty of numerous violations of conspiring to violate the FCPA's anti-bribery provisions and the federal money laundering statute, as well as substantive violations. And Ho brought 4 challenges that I thought were very, very interesting, and 2 specifically related to the FCPA. First, he said he was charged with as being a domestic. He was charged. So he argued. Sorry, let me start over. He said first the evidence showed only that he was acting to benefit a foreign entity, not the U.S.-based NGO that formed the predicate for his conviction under the FCPA's domestic concern provision. And then he argued, and by the way, you can't charge me under both the domestic concern and the territorial jurisdiction provisions of the FCPA because those are mutually exclusive. And the Second Circuit rejected both arguments. First, the court held that the FCPA does not require a U.S. entity to be the beneficiary of the corruption, but it only requires that the defendant was acting on behalf of a domestic concern to procure business for any person. So here he was allegedly acting for the U.S. NGO to benefit the Chinese entity. And the court held, as long as you're working on behalf of the domestic concern and paying bribes, it doesn't really matter who the recipient of that benefit was. And it was okay if it was the Chinese entity, which is very interesting. I mean, that does, to be frank, comport with the way that I read the statute. It says on behalf of any person. And so that makes sense, but it was an interesting and novel issue nonetheless. And then the court held that the domestic concern jurisdiction and the territorial jurisdiction were not mutually exclusive. So for us geeks, as you call us, Tom, DD2 and DD3 are not mutually exclusive. And here I'll quote it because I thought that the Second Circuit had a really good and concise way to explain it. The FCPA's statutory language contains no indication that the provisions are mutually exclusive or that both sections would not cover a director, like the defendant in this case, who acts on behalf of both a domestic concern, here the U.S. NGO, and on behalf of a person other than a domestic concern, here the Chinese entity. Nothing in the language of the statute or the Hoskins decision prevents an individual from fitting within more than one of the FCPA's 3 categories, particularly whereas here that individual acts on U.S. soil on behalf of both domestic and foreign entities. So it's interesting you mentioned the Hoskins decision. That, of course, the argument there was he didn't fit into any of the categories. Here, DOJ alleged that Ho fit into 2 separate categories, and the court said that was fine. Hoskins doesn't prevent that, and neither does the statute itself. Ho then also raised some pretty interesting jurisdictional arguments for the money laundering offenses that we don't need to get into here, but it was pretty interesting as well. But those 2 FCPA questions, I agree with you. They should have got a little more attention, and they're very useful to read.
James, there'd been I think many people were disappointed in the current Brazilian president. They felt like he took his foot off the gas of the Brazilian prosecutors looking for corruption and bribery in Brazil. But we had an announcement in December that the Brazilian government announced a 5-year anti-bribery, anti-corruption plan. And I was wondering what your thoughts on that might be.
Very interesting question, Tom, whether this really does signal a commitment to continue to pursue anti-corruption, or, is there maybe something going on behind the scenes? I think it's a little bit mixed. So to set the stage, in early December, the Brazilian government announced a 5-year anti-corruption plan. It adopts recommendations from the UN, the OECD, and the Organization of American States. And the plan's primary objective is to coordinate cooperation among government agencies as they each work to combat corruption. Put a pin in that. I'll come back to that in a minute. The plan sets out 142 actions. They cover prevention of corruption, detection of corruption, and fiscal responsibility and accountability. And then it also contains measures related to private sector compliance programs, lobbying and public integrity, whistleblowers, investigations, leniency agreements, and international cooperation, among other measures. In putting out a plan like this, it certainly does see that Brazil is going to continue to focus on anti-corruption. And I think in that regard, we should take it as such. But the one hesitance I have, and the pin I put in there, is that even though this document says that one of the purposes is to coordinate enforcement and cooperation among government agencies, it left out the Brazilian Federal Prosecution Service. And that has been the service that really led Operation Car Wash and all the things, all those enforcement actions over the years, which the current Brazilian president is not a fan of. So one could be cynical. Is this a way to try to undermine the MPF, which has been very successful? Or is one to be optimistic to say, this really is a coordinated plan to move forward and continue to pursue anti-corruption in the future? I think it's probably a little mixture of both. But I think the main takeaway is we do have to expect that the anti-corruption push in Brazil will continue for at least the next 5 years in some form or fashion.
It sounds like this is one we may revisit in a year or two, James.
I think that's right.
James, I want to end on literally something that happened on January 1 of 2021, which was Congress overrode the president's veto of the National Defense Authorization Act. And for the anti-corruption compliance community and the AML compliance community, there were significant reforms or amendments, I should say, to the Bank Secrecy Act. And what I was interested in your views is, of course, the Bank Secrecy Act focuses on financial institutions, perhaps financial service companies. There were a couple of others, art dealers, some real estate sellers. But I'm thinking that the reforms, particularly around shell companies and ultimate beneficial owners, anonymous ownership, that is really going to inform anti-corruption enforcement all the way down to anti-corruption compliance and specifically even down to due diligence. So I was wondering if you see this change at the highest level around financial institutions and those issues around money laundering maybe as a way that the Department of Justice would start talking about this in the context of FCPA enforcement.
Yeah, really interesting. And just I'll note we covered it in our December newsletter because it was actually passed in December. It was vetoed in December, but everybody knew it was going to get overridden. The veto was going to get overridden, so we went ahead and covered it in December. But yeah, I think it's a really potentially very important measure. And I love the language that Congress included, by the way, in this act. It said it is a sense of Congress that malign actors seek to conceal their ownership of certain corporations, limited liability companies, and similar entities formed under state law. And then they say to facilitate foreign corruption, money laundering, and other illicit activities. This has been, I think we may have talked about this in the past. I'm sure you've talked about it before. Globally, there's been a real outcry against shell corporations and the ease with which shell corporations can be formed and the lack of transparency in their true ownership. And it turns out the U.S. is one of the worst countries in the world when it comes to that. Now, there can be all number of legitimate reasons for forming companies like this. Obviously, the fact that you form a company like this is not indicative in itself of anything illegal, but they are subject to abuse. And it's very interesting to me that Congress specifically pointed out the use of shell companies formed in the United States to facilitate foreign corruption. So I do think that this is something that, the disclosure requirements are probably not going to apply to most big companies. That's really not what this is aimed at. And if you go through the act itself, there's criteria of who has to disclose, and it does really seem to exclude a lot of major companies and things like that. But you raise a good point. this could provide, for example, new avenues for due diligence. When you're looking into the third parties you're dealing with, if this works, you're going to be able to get a better sense of who you're dealing with. And, this should probably be a new thing that compliance professionals look at when they're doing third-party due diligence. We'll see how much of an impact it has. It seems like a very good step towards transparency and the ability to know who you're dealing with. And so we'll hope for the best and continue to monitor this to see how it's used by companies.
James, unfortunately, we are near the end of our time for this episode, but I wanted to thank you again. We're going to link to the firm's newsletter in the show notes, and I look forward to seeing what January and February bring.
Lots of snow, probably, at least up here in D.C. Thanks, Tom.
Hello, everyone. This is Tom Fox. Thanks so much for listening to this episode. I'm extraordinarily pleased to announce the pre-publication pre-sale of my latest book, The Compliance Handbook, Second Edition, published by LexisNexis. It will be published in April. Quite simply, this is the best single-volume, single-author book on compliance programs. The creation, the design, the implementation, and the enhancements of best practice compliance programs are all laid out in this book. If you're in the compliance field, the compliance discipline, this is the book for you, far better than any other book on the market, if I may say so myself. I'm going to link to it in the show notes for a pre-sale. There's also a discount. Thanks again for listening to this episode of the FCPA Compliance Report, and I hope you'll join me again next week for another episode.